Chapter 9 Regulatory Approvals. According to Rule 19, Sub-Rule 7, SEBI may waive off some of its regulations from compliance. Regulation 2 Scheme of Arrangement. The listed entity shall ensure that any scheme of the arrangement, amalgamation, merger, reconstruction, reduction of capital. So 5 things: arrangement, amalgamation, merger, reconstruction, reduction. 2A, 1M, and one more last is R. AMR. Like MTR, AMR. To be presented to any court or tribunal does not in any violate or override or limit the provisions of securities law, means it should comply with securities law, or requirements of the stock exchange, provided that this regulation shall not be applicable for units issued by mutual funds which are listed on recognized stock exchange. So for mutual funds this provision will not apply. Mutual fund not apply. The listed entity desirous of undertaking a scheme of arrangement or involved in a scheme of arrangement shall file the draft scheme of arrangement proposed to be filed before tribunal under section 232 to 34 and scheme of arrangement by way of reduction of capital under section 66 of the Companies Act 2013 along with a non-refundable fee as specified in schedule Roman number with the stock exchange for obtaining observation letter or no objection letter. And then scheme of arrangement by way of reduction of capital under section 66 of the Companies Act along with the non-refundable fee. So fee is non-refundable as specified in the schedule 11 with the stock exchange for obtaining observation letter or no objection letter before filing such a scheme with any court or tribunal in the matters of requirements specified by the board or stock exchange. So crux is given in the second point also. First point crux is also there in second point. Like any company who is desirous of undertaking a scheme, first it has to obtain a observation letter or no objection letter from stock exchange. After that only it can file the draft with the tribunal for approval. And that observation letter or no objection letter will be valid for 6 months. The listed entity, next third point, the listed entity shall place the observation letter or no objection letter of the stock exchange before tribunal at the time of seeking approval of scheme of arrangement, provided that the validity of the observation letter or no NOL of the stock exchange shall be 6 months from the date of issuance, within which the draft scheme of arrangement shall be submitted to the court or tribunal. The listed entity shall ensure compliance with, means should follow all the rules and regulations. Upon sanction of the scheme by the court or tribunal, the listed entity shall submit the documents to stock exchange, as prescribed by the board and or stock exchanges from time to time. Nothing contained in this regulation shall apply to the draft scheme, means they are not required to get the observation letter or no objection letter when provided which is solely provide for merger of a wholly owned subsidiary with its holding company. So one wholly owned subsidiary and holding company is getting merged. For that not required to get any OL or NOL from stock exchange, provided that such draft scheme shall be filed with the stock exchange for the purpose of disclosure. Only for the purpose of disclosure we have to file, and the requirements as specified under these regulations and under regulation 94 of these regulations shall not apply to restructuring proposal approved as a part of resolution plan by the tribunal under section 31 of the IBC. So IBC related resolution plan got approved, so that has to be informed to the stock exchange. For that also not required to get OL and NOL. Regulation 94 will read further and done. Regulation 94 Draft Scheme of Arrangement and Scheme of Arrangement. The designated stock exchange, upon receipt of the draft scheme of arrangement and the documents prescribed by the board as per Regulation 37, shall forward the same to the board. And the board is SEBI. The stock exchange shall submit to the board. Second point, the stock exchange shall submit to board its objection letter or NOL on the draft scheme of arrangement after inter alia ascertaining whether the draft scheme of arrangement is compliance. Only when they will to issue NOL or OL, they will check that whether the company is in compliance with the securities law. If yes, they will issue within 30 days of the draft scheme they will issue, and of the arrangement or within 7 days of the date of receipt of satisfactory reply upon the clarification from the listed entity. So normally within 30 days, but if there any defect or somewhat, they will seek the reply from the listed entity, and after listed entity give its reply, within 7 days they will give the NOL or OL from the listed entity, and or opinion from the independent chartered accountant, even listed entity and independent chartered accountant, either or, and if any sought by the stock exchange as applicable. Sometimes stock exchange ask both from company and from CA, and sometimes either of the one they'll ask. However, they ask like that, they have to reply. The stock exchange shall issue OL or NOL to listed entity within 7 days of the receipt of comments from the board, that is SEBI, after suitably incorporating such comments in the OL or NOL. And validity is 6 months, and the stock exchange shall bring the observation or objections as a case may be to the notice of court or tribunal at the time of approval of the scheme of arrangement. And upon sanction of a scheme by the tribunal, the designated stock exchange shall forward its recommendations to the board on the document submitted by the listed entity in terms. So listed entity first it will submit to designated stock exchange now, then that will give the objections or anything and to ask rectify and all that recommendations the designated stock exchange will give to SEBI. So in simple, 94 is first company will submit a draft to designated stock exchange, and designated stock exchange to issue the OL or NOL, first it will submit to SEBI. SEBI will give some inputs, and after incorporating all the inputs given by the SEBI, it will give the OL or NOL to company. And at last, after all things have been done, the stock exchange will submit the recommendations to SEBI. So this regulation no need to follow by the company which got through IBC. Regulatory approvals from RBI required in case of merger of two banking company or cross-border merger. The Reserve Bank has a what? Discretionary power to approve the voluntary amalgamation of two banking companies under the provision of 44A of Banking Regulation Act. No banking company shall be amalgamated with another banking company unless a scheme containing the terms of such amalgamation has been placed in a draft before the shareholders of each of the banking company concerned separately and approved by a resolution passed by a majority representing 2/3 in value of the shareholders of each of the said companies present either in person or by a proxy at a meeting called for the purpose, and notice of every such meeting shall be given to every shareholder of each banking company indicating the time, place, object of the meeting, and shall be published at least once a week for 3 consecutive weeks in not less than two newspapers which circulate in the locality or localities where the registered office of the banking companies are situated. So registered office. Third, if the scheme of amalgamation is approved by the requisite majority of the shareholders, it shall be submitted to Reserve Bank for sanction, and shall if sanctioned by the RBI by an order in writing passed in this behalf be binding on the banking companies concerned and also on the shareholders. Any shareholder who has voted against the scheme, that is dissenting shareholders of the amalgamation at the meeting or has given the notice in writing at or prior to the meeting of the company concerned or to presiding officer. So he given notice or at the directly he voted against. That he dissents from the scheme, he shall be entitled in the event of the scheme being sanctioned by the RBI to claim from the banking company concerned in respect of shares held by him, that the company and their value as determined by the RBI when sanctioning the scheme by the Reserve Bank as to value of the shares to be paid. So for the persons who have dissented, they should be get paid. To the dissenting shall be final for all the purpose. On sanctioning of a scheme of amalgamation by RBI, the property of the amalgamated banking company shall be transferred to and vested in the liabilities of the said company shall be transferred to and become the liabilities of the banking company which under the scheme of amalgamating is acquired the business of amalgamated banking company subject to all means transferred assets and liabilities will be transferred to transferee, same thing. Where a scheme of amalgamation is sanctioned by RBI under the provisions of this section, the Reserve Bank may by a further order in writing direct that on such date as may be specified therein banking company which by a reason of amalgamation will cease to function and shall stand dissolved and on such direction shall take effect notwithstanding anything to contrary, means transferor company will get dissolved. Where the Reserve Bank directs a dissolution of amalgamated banking company, it shall transmit a copy of order directing such dissolution to the registrar before whom banking company has been registered, and on receipt of such order, the registrar will strike off the name of the company. If A bank, B bank is there merging to C bank, so A and B will get dissolved, C will be in existence. So order of dissolution shall be sent to the registrar so that registrar can strike off the name of the banks. Such an order shall be conclusive evidence that all the requirements of the section relating to amalgamation have been complied with. Means once they order for strike off, it means all the things have been done. Nothing shall affect the power of CG to provide for amalgamation of two or more banking companies under 237. Section 237, that is, if banks are merging because of the law of the order, then they no need to follow all the rules. So, approvals from Insurance Regulatory and Development Authority, that is IRDA. In these two sections are the first 36 and 37. 36 deals with how do you take approval from the IRDI, that is authority, before merging of two insurance companies. So, before merging, how you will take the approval. Next, 37. Once the merger is done, what and all documents you have to submit to IRDI. Section 36 of Insurance Act deals with the sanction of amalgamation and transferred by authority. It states that when any application is made to IRDI, the IRDI shall cause a notice of application to be given to holders of any kind of policy insurance. So, in company for shareholders, in insurance company for insurer concerned, along with the statement of the nature and terms of the amalgamation. Concerned along with the statement of nature and terms of the amalgamation. So, first notice that merger is happening and statement of nature and terms, means small or big, which merger is happening, nature, to be published in such manner for the such period as may be direct. And after hearing the directions and considerations, the objections of the policyholder and other persons who is considered entitled to be heard, may approve the arrangement and shall make such consequential order as may be necessary to give effect to arrangement. 37, that is documents. 36, once again, like the insurance company who want to, the two insurance company who want to get merged, they will file an application with the IRDA. IRDI will issue the notice so that insurer, that is the policy holders, can get to know that these two banks are merging. They can give their inputs, objections if any. Along with notice, there will be statement also. That's all. 37 of the Insurance Act 1938 deals with the statements required after amalgamation and transfer. It states that where an amalgamation takes place between any two or more insurer, or where any business of an insurer is transferred, so between two or more insurer, or where any business of an insurer is transferred, whether in accordance with the scheme confirmed by IRDA or otherwise, the insurer carrying on amalgamated business or the person to whom the business is transferred, as the case may be, shall within 3 months from the date of completion of amalgamation or transfer furnish the relevant docs to IRDI. That is, after merger, which company is presently running the business, that is amalgamated company, so that company has to submit the documents to IRDI. First, certified copy of the scheme, declaration signed by every party concerned, in case of company by the chairman and the principal officer, that to the best of their belief, every payment made or to be made to any person whatsoever on account of amalgamation or transfer fully set forth, and that no other payments beyond the set forth have been made or to be made either in money, policies, bonds, valuable securities, other property, by or with knowledge of any parties to the amalgamation. So, according to the terms only will make the payment. No excess or no reduction will be there. where the amalgamation or transfer has not been done in accordance with the scheme approved by the authority under 36. In some situation, IRDA approval not required. That is this. Then, if IRDA approval is not required, then they have to give extra disclosures in the A and B's. Along with that, these extra also they should give. First, balance sheet in respect of the insurance business of each of the insurer. Balance sheet, both companies, both banks. Such amalgamation or transfer prepared in the form set part 2 of the first schedule and in accordance with the rules. Certified copies of any other report, that is valuation or auditor report, like that. Scheme of the amalgamation or transfer was found. So in gist, if company required to take approval of the IRDA, then section 36 and in section 36 should notice the should give the notice and seek objections and copy of the scheme and declaration. If companies banks are not required to take approval, then copy of the scheme, declaration, balance sheet and copy, certified copy. Section 37A. This is same as the section 237 of Companies Act. Like how CG can order merger in the interest of the public interest, same like that even IRDA can order for merger in the interest of public, policyholders or insurance market. Section 37A of Insurance Act deals with the power of IRDI to prepare scheme of amalgamation. It says that if IRDI is satisfied that in the public interest, in the interest of the policyholders, or in order to secure the proper management of an insurer, or in the interest of insurance business of a country as a whole, it is necessary so do so, it may prepare a scheme for amalgamation of that insurer with any other insurer. So it IRDA itself can prepare the scheme for the amalgamation of A bank with the B bank. IRDA authority itself can prepare a scheme for amalgamation. No such scheme shall be prepared unless the other insurer has given the written consent to the proposal. So, if A bank want to in the public interest and all, IRDA thinking to merge A bank with the B bank. So, B bank is all doing good. It has to take the B bank written consent. The scheme aforesaid may contain provisions for all or any of the following matters. First, the constitution, name, registered office, capitals and assets, powers, rights, interests, authorities, privileges and liabilities, duties and obligations of the transferee company, that is B bank. The transfer of the transferee insurer, the business, properties, assets, liabilities, insurer on such terms and conditions as may be specified in the scheme. Means in scheme what and all mentioned about assets, liabilities and that all. And any change in the board of directors or the appointment of a new board of directors, change or new of the transferee insurer and the authority by whom, the manner in which and other terms and conditions on which such change or appointment shall be made, and in the case of appointment of a new board of directors or any director, the period for which such appointment shall be made. Means if new person want to be employed, what will be the term, that also will be in the scheme. So first constitution, next transfer of assets and liabilities and change in the board, either change or new, and fourth alteration of articles MOA and AOA of the transferee, because now transferor will cease to exist. Transferee in the transferee all the changes has to make now. So alteration for the purpose of altering the capital thereof for such other purposes as may be necessary to give the effect the amalgamation, subject to the provisions of scheme, the continuation by or against the transferee insurer of any actions or proceeding pending against the insurer. So now in transferor company what and all cases that will be transferred to transferee, they has to go through. Now the reduction of the interest or right which the shareholder, policyholder and other creditors have in or against the insurer before amalgamation, to such extent as the adjudicating authority considers in the public interest or in the interest of the shareholders, policyholders, other creditors for the maintenance of the business of the insurer. So the IRDI may do any changes in respect of rights. Next, the payment in cash or otherwise to the policyholder and other creditors in full satisfaction of their claim. So payment in cash or otherwise to the policyholder. Payment in cash or otherwise means in kind also sometimes. in respect of their interest or rights in or against the insurer before the amalgamation, or where the interest or rights aforesaid in or against the insurer has or have been reduced. So if interest have been reduced, then in respect of such interest or right as so reduced, the allotment to the shareholder of the insurer for shareholders held by them therein before the amalgamation, where their interest in such rights have been reduced of the shares in the transferee insurer, and where any shareholder claim payment in cash and not allotment of shares. So in the before clause we have read that IRDA may reduce the rights or whatever. So how much it has reduced, for that they will get the compensation. It may be in the form of shares or cash, however the policy holder or shareholder ask. And not allotment of share, where it is not possible to allot shares to any sharp holders of the payment in the cash to those shareholders in full settlement of their claim in respect of their interest in shares in the insurer before amalgamation, where such interest has been reduced in respect of the interest. Again repeated, a copy of scheme prepared by the authority shall be sent in draft to the insurer. Means for both A bank and B bank, a copy of the scheme will be given. Draft scheme to send to insurer and the transferee insurer and the other insurer concerned in the amalgamation for suggestions, objections, if any. The authority may make such modifications in any, if any, in the draft scheme as he may consider necessary in the light of suggestions or objection received from the insurer and also from transfer insurer and any other insurer concerned in the amalgamation, and from any shareholder, even from shareholder also we can receive the objections or suggestions of each of the insurer and the transferee insurer. The scheme shall thereafter be placed before CG for its sanction. Every policyholder or shareholder or member, whatever they have the rights in A bank, they will have the same rights in a B bank also after the amalgamation. Where the interest or rights of any shareholders or member are less than the interest, the original insurer, he shall be entitled to the compensation which shall be assessed by the authority. So if any change in the rights compared to the old bank, in the new bank any change is there, for that the specific shareholder or whatever policyholder, he will be compensated by the IRDI. The compensation so assessed shall be paid to the shareholder or member by the insurance company resulting from such amalgamation, because there is the one defaulted right. Any member or shareholder agreed by the assessment of the compensation, means they expected 50 lakhs but bank gave only 5 lakhs, so they are agreed. Authority may within 30 days from the publication of such assessment prefer an appeal to SAT. So to SAT, the sanction accorded by the CG shall be conclusive evidence that all the requirements of the section relating to the amalgamation have been complied with, and a copy of sanctioned scheme certified in writing by the officer of a CG to be true copy thereof shall be in all legal proceedings be admitted. So this copy of the scheme will be admitted as a evidence to the same extent as the original scheme. Copy of sanctioned scheme will be admitted as an evidence. The authority may in like manner add to or amend or vary any scheme made under this section. So authority, even if it desire, it can make changes in the sanctioned scheme on and from the date of the coming into operation of the scheme or any provision thereof. The scheme or such provision shall be binding on the insurer. So scheme on the date it gets affected will be binding on the insurer, or as the case may be on the transferee insurer, so transferee company, and any other insurer concerned in the amalgamation, and also on all the shareholder, policyholder, creditors, employees of each of those insurer and of the transferee insurer, and on any person having any right or liability in relation to any of those insurer or transferee insurer on and from such date as may be specified by CG in this behalf, their properties, assets of the insurer shall by virtue of and extent provided by the scheme stand transformed and vest in the, and the liabilities of the insurer shall by virtue and to the extent provided in the scheme shall stand transferred and become the liabilities of transferee. So everything of transferor will become the transferee. If any difficulty arises in giving effect to the provisions of the scheme, CG may by order do anything not inconsistent with the such provisions which appears to it necessary or expedient for the purposes of removing the difficulty. So CG can take any action as it thinks good. Copy of every scheme made under this section of every order made shall be laid before each house of the parliament as soon as may be after the scheme has been sanctioned by the CG, or as the case may be, order has been made. Next, approval from Telecom Regulatory Authority (TRAI). The Department of Telecommunication, Government of India, Wide Circular dated issued guidelines for transfer or merger of various categories of telecommunication services licenses authorization under Unified License on Compromise, Arrangement and Amalgamation of Companies. The TRAI on 30th November 2017 has released recommendation on ease of doing telecom business. So chapter 1 was background, chapter 2 is inputs received from stakeholders and have been analyzed, and chapter 3 list of recommendations. So we are done with chapter 9 from S Academy book.